Welcome, everybody, to another episode of Tax Sale Insiders. I'm your host today. It's Brian Seidensticker from Tax Sale Resources. With me is, kind of an old regular on the show, Stephen Morel from Jurisd. He's owner and founder and CEO of Jurisd. But welcome back, Stephen. Thanks for joining us.
Always a pleasure to be here. Thanks for having me.
So, I think we were chatting just before hopping on here. We've talked about these coming changes in Louisiana for years, quite frankly, and many states the same way. But the changes are finally coming, and it's real. But before we dive into that, can you get me and the audience a little up to speed on what the system used to be, kind of what it is currently, and then we'll dive into what has changed, and we'll go from there. So what did it used to be? Like, what was the system prior to the changes taking place?
I think unofficially the system that everyone kind of felt Louisiana had was just wacky, right? It was just Louisiana's system. It was crazy, and it's not far from the truth. I mean, they were one of the only ones that kept the ownership bid down at the auction, and so along with many other things, it just became its own animal. But yeah, everything before 2009 was in Louisiana was very different. It's been that same way for over 100 years, and it really just was this: we're selling the property at the tax sale, which has all kinds of problems, as you might be well aware of today, more so than ever. And so in 2009, a couple of years of working on the statutes and a new system was implemented, and it took a while to gain some legs, but eventually it gained some good traction, and it really changed it from a tax deed state to a kind of a hybrid, but effectively a tax lien. I mean, the hybrid thing just makes people feel more confused. So, like, what does that mean? Either you're selling the property or you're selling a lien. I mean, let's lay it down like it is. And so, in Louisiana since 2009, and including through right now, the tax collector sells the lien on the property for payment of the delinquent taxes. It comes with the right to foreclose the right of redemption. So there isn't a subsequent auction like Florida or like other states, or like a mortgage foreclosure. That is not part of the process today.
Right.
The 3-year redemption rate, and which is kind of on the long side, but redemption rates are very high. So if you're going for the redemption play, it's a good state, and the rates are good. So you're talking about 1% per month and a 5% penalty that's tacked on at the tax sale.
Right.
And so the biggest issue there now, the question is like, well, what if it's working, and the cases and the courts are kind of blessing it and saying, yeah, this is pretty good. I change. And like, well, because honestly, the bid down of ownership percentage is really antiquated. It creates more problems than it's worth. And from the perspective of really most people across the different spectrums, both from the tax collection arena, the investor arena, except for the handful that have really figured out the game plan and how to make money from it. Of course, They don't want anything to change, but from a unbiased standpoint, it's problematic. Imagine having a percentage ownership of something and having that recorded in the public records, and having how the title world deals with that. Right, it is a nightmare. Right. And a lot of the county, or in our state call them parishes, government officials like the assessor and tax collector, they don't know how to figure it out either. And so you have a situation where you have a partial interest of something that gets its own new tax bill number, even though we're talking about the same piece of land. There's just like you and your siblings co-own something from your parents. It's still one piece of land, right? It's just a partial ownership in that one thing, but they're going crazy with it and creating new tax bills, and then putting that tax bill up, as a partial interest of something. It's just a nightmare, and it needed to go away. The problem with getting it to go away previously is that system was baked into the Constitution. And so it made it way harder to resolve. And the 2009, the committee who did that 2009 revision just said, look, let's get what we can get done. And to their credit, they've made an amazing advancement in stabilizing what was previously a completely wacky system, as I mentioned.
Some progress is better than no progress.
Yeah, correct, right. And it was significant, but again, that it did retain that partial bid down of ownership. So, as you might imagine, teeing that up to like, well, what was the change? And I can tell you that before we get into the details of the change, that in last year in 2024, the legislature did pass a comprehensive overhaul of Louisiana's tax sale system. It was signed into law by the governor with two conditions. Number one is a delayed effective date of January 1st, 2026. And the second one was to a constitutional referendum. So it had to pass popular vote. And it did. In December of last year, it went to the voters, it passed. And so it's definitely happening now. For years, we've been talking about changes coming in Louisiana. Now it actually has happened. It's just got a delayed effective date of 1/1/26. So the key changes, right? That's what we want to get to. And how does this affect investors for the most part? The biggest one, of course, is, as you might imagine, getting rid of the bid down ownership percentage. The system of dealing with competitive bids at the tax lien auction in Louisiana from 1/1/26 on will be a bid down of the interest rate that's offered to the investor for paying the delinquent taxes. And it starts at 1%, which is the same rate that they've been collecting on delinquent tax purchases to this point, and is the maximum now that that you can get. The floor, however, is 0.7. So in 1/10 increments, that the bidders can bid down from 1 to 0.9 to 0.8 to 0.7, or directly to 0.7 if you want to just jump right, kind of like equivalent of quarter point order, right? You can go right to the bottom and just stop the auction on that property. So not a whole lot of bidding, bidding ability, if you will. Like there's only like 4 increments, but I think the idea there was what kind of a compromise between the different powers that be about having that be the system. First off, having an interest bid down, starting at 1 and going down by 1/10 of a point, but never really getting so low that it makes it like, this is just silly. Like, why are we even here?
Right.
Like, come on. And so that's just where it landed. So let's wait and see how it actually plays out. But 0.7, obviously still an attractive interest rate over time, especially if it's accumulates over a number of years. The 5% penalty, obviously a much bigger hit now, like relative to the interest rate, especially on shorter term redemptions, is applied pre-tax sale. And this is a big change from a legal standpoint. If more of the legal and title listeners out there may understand this, that if there's a problem with the tax sale and there's a penalty assessed at the tax sale, then that penalty has to be looked at as being taken off, right? Because you can't have things that flow from a problem, right? So this attacks on the 5% penalty after 90 days of delinquency as a rule. So it's kind of like the 1% per month, but at 3 months, there's an additional 5% tacked on. And that goes into the tax sale in that way. So the bidder is able to bid without paying that 5% so that it can reap the benefits of that 5% after paying at the tax sale. But it's assessed to the tax sale, the tax delinquent at that moment, so that if they want to pay it pre-tax sale, they can do so, but they would have to pay it with that 5%.
So that 5% would still go to the investor, right?
Absolutely.
If there's a problem or if they redeem it, like immediately. Correct.
It still acts as a carrot. It still acts as a part of the incentive for participating in the tax sale. But the way that it was kind of, I remember being, I was in previous videos, I may have mentioned that I was part of a committee that advised the legislature on these changes. And one of the, this was kind of a difficult one to get over, was sort of like, where do we get this 5% out of the weeds, like, so that it can be applied, but not become a problem of being a due process issue, if you will, but still allow the investors to take advantage of it. Because if you just tack it on, and that becomes the basis price, then like what do they gain from it, right? Nothing.
Right.
So that's there. And while we're on the topic of the 5%, a really big change, especially if you're playing the long game here and you're going to be buying in Louisiana for year over year, are the subsequent taxes. In Louisiana previously, before this current change I'm talking about, there wasn't a great incentive to pay the subs. Even you might do it as a rule just because that's your business model. But to be honest with you, you didn't get a whole lot for it. You just continue getting 1% per month. And really it's the collectors didn't really come together to add it all up along, to, in the event of a redemption, to make sure you get the subs with your tax sale payment, right? It was just sort of, you had to really kind of like go shake the trees and get everything you were owed. But now you're going to get 5% on subsequent payments as well. Now, only after it falls delinquent. The only clarification that isn't in the statute yet, and that needs to be, and we have time to do this because of the delayed effective date, is if the first year of delinquency, the 5% applies after 90 days, in the subsequent tax situation where there has been a tax sale, which is still unredeemed, and the next year's tax bill now is due, the way it's written right now, it's the 5% penalty would, in my opinion, would apply on day one of the delinquent period, which would be 31 days or the first day of the second month, right? Not 90 days. And so, but that's inconsistent with how it's applied in year one. So I'm not really sure if that's something that needs to be reconciled. Either way, it's a big carrot for the investor to then pay those subs. It benefits the county, right? Because they get their tax dollars earlier. It's not, but you're going to get that same bump that you'd get as if you went to tax sale. So literally what investors would sometimes do is not pay the subs and roll the dice and let it go to tax sale again. And so in the hopes of getting 50%, even if you wouldn't get it, it's like, well, it's better than, than just the 1% or whatever. So this incentivizes equally across the board. It's a really good change. The second big change for investors is going to be the redemption period due diligence. Louisiana has always allowed for investors to step up and send out their own notifications to interested parties at a certain stage of the process. And there hasn't been a direct benefit for doing that. There's been a like, well, if they get the notice here, then they can't come back later and assert a nullity challenge down the road. That's nice if you end up getting the property or if it doesn't redeem, but 90-something% redeemed. So it's like you're kind of playing this like really belt and suspenders approach, if you will, to protecting your asset. But now there's a dollar amount that's reimbursable to the investor for conducting that redemption period due diligence that can be proved by a simple affidavit to the collector. It gets added on to the delinquent amount that's owed in the event of redemption, so that you're actually going to get that in your redemption price. Makes it effectively, and it's high enough. It's a $500 cap, which is more than like Juristy does this as a service, as one of our products, one of our core products for tax law investors, is we automate your redemption period due diligence for you, no matter what state you're in. So in Louisiana, like you upload your portfolio, and as soon as it needs to happen by law, everything is done for you, right? And now that the cost of paying us to do that is added to the redemption amount, and we're looking at a way to automate getting the proof of that payment back to the collector for the investors, so that they don't do that either, and just giving them a hands-off approach to it, right? And so this is like, hey, yeah, pay us, but it might sound self-serving, but it's just the way the law is now. You can get that money back, so now you're going to get the best of both worlds.
That's awesome.
So you had a question there, or do you want me to keep going?
No, I was going to comment in general. It's immensely more appealing, right? And I think more straightforward, right, than the previous system. And maybe you're going to dive into this, but I guess how's the post-redemption process going to look? Is that changing?
Yeah, that's fundamentally changing. So it's changing to that dual sales system like Florida, and where the second auction is akin to like a mortgage foreclosure. So you're foreclosing the right of redemption. You are a secured lien owner, which is consistent with the idea that this is a lien, right? Mm-hmm. This is not ownership. You don't have some kind of quasi right to the ownership that greater than anybody else, other than to foreclose your lien, right? And create a liquidity event like an auction. And so the redemption period stays the same. You can relatively the same time period, about 180 days prior to the end of the redemption period is when you must send now, it's a requirement, your redemption period notifications. And that allows you to file suit to foreclose the right of redemption, or to convert to create a sale of the property the first day after the 3 years has expired of the redemption period. So if you're really trying to move this along quickly, right? This is a property you want to liquidate. Sending out those notifications, it makes sense to do it as like automatically, no matter what, because even if there's a good chance you're going to get that redemption in the last 180 days, right? And a lot of redemptions do occur in that time period. You're going to get your money back anyway. And if it didn't redeem, you'll be legally eligible to commence the foreclosure proceedings on day one, right? And of course, as you know, from doing this long enough in your business, notifications work in creating redemptions. I mean, as long as they're smart, right? It's like not like direct mail where you're just hoping to get a certain percentage of hits. Like smart mail, which is one of our products, allows targeted interested party notifications to get to the right person at the right time, and it just creates payments. It just does. And not only does it satisfy legal requirements, but it creates redemptions. So,
and just to kind of supplement that, it's not sending a snail mail letter to the address, right, with a notification, which if there's nobody living there, or most of the time it's not the owner living there, right, that doesn't do anything. What you're talking about is the smart aspect, is like figuring out where the owner actually lives and sending a letter to the owner where they will actually receive it.
And the owner and all of the interested parties, anyone who has a recorded interest in the property, mortgage company, or a recorded leaseholder, anyone who has a recorded interest in the property is going to be picked up on, or needs to be picked up on in a title search, and then provided with the same notification. Owner being the most sensitive of those people, of course, because they're the ones that stand to lose the property, the ownership.
Right.
But yeah, interestingly enough, like Louisiana's current law got this part of it really, really well. And this part of it meaning like the importance of notifications, of conducting good due diligence, of timely notifications, and for trying to get people aware of this problem, of this tax, of what's the consequences that are about to happen, and not a final opportunity to do something about it, is the new law adopted virtually verbatim every part of the current law for this activity, for the notification side, and literally just added on one more requirement: to send a notification to address to occupant. Which was something we did on the struck off properties that we call adjudicated properties. We always do that as a rule, but that came out of the title insurance realm because we were just trying to be overly protective of the risk, but not necessarily because of a legal requirement. But again, they're just trying to make sure that this only goes to a foreclosure auction if there's no other option, right? Reasonably speaking. So the next big thing for investors, though, and if they're following along the timeline here, is whether you wait a little longer to send your notifications out or file suit, whatever, that's up to you. Although for the first time ever in Louisiana, there's now a statute of limitations on how long you can wait to do that. So it used to be perpetual. Literally, you could do it 100 years later. You can file your quiet title. Now there's a 7-year statute. We call our statute of limitations the prescription period in Louisiana, or in fact a peremption period, because it can't be stopped, it can't be delayed. And so when 7 years runs from the date the tax sale certificate is recorded, that's it, last chance. So that means that 3 years redemption period, right? It didn't redeem, you got 4 more years to file that lawsuit. But of course, you can't file the lawsuit until you send out your 180-day notifications. So you got to make sure that that's factored in. If you're really waiting to the last possible second, you would have 6.5 years to send out your notifications, right? And then you'd have that last, if you want to wait to the last day, which I don't recommend. So that's like kind of what the time frame in which you can enforce your action. Now, enforcing the action is completely different. It used to be a suit to quiet title. It used to be a suit to quiet title, which is converting your tax lien into this legally now recognized deed, right? Like just as a matter of the court blessing that you did everything correctly. There's no subsequent auction, that kind of thing. Today, in the new law that will take effect in 2026, it will in fact be a judicial foreclosure of the property, and so the price to pay that off is now called the termination price, not the redemption price, because the redemption period is over, right? But just like in a mortgage foreclosure, if the debtor shows up and wants to pay the entire amount, including additional cost, fees, whatever's been tacked onto it at that moment in time, the law is going to let them do it, right? And that's going to stop the foreclosure, and that's permitted here too. So you might think, well, hang on, redemption period's 3 years. Does this just give this like extra time to redeem? And it does. But again, it's consistent with the type of system that we moved into, right? You can't have your cake and eat it too all the time. And in this case, you have a system that allows for the foreclosure of a property at, in a subsequent sale. And if the debtor wants to pay everything off, then they're going to be allowed to pay everything off. Now, at some point when the gavel is dropping, it's like, it's too late, right? But like at some reasonable stage, and I think there is a time limit. I don't recall exact days, but there's a time limit leading up to the sale when it's like the last time you can possibly pay.
Right.
But it will include all the additional costs, filing fees for the lawsuit, right? And very importantly, attorney's fees, which is before now not been recoverable in a suit to quiet title in Louisiana, unless you were having to partition the property because you bought a partial interest at the tax sale. And that was really only uniquely available because of partition law, which doesn't necessarily involve tax sales. It just means it's a partition. Tax sales who buy a partial interest today, who buy a partial interest in a tax lien in Louisiana today, and it doesn't get redeemed, have to liquidate the property, right? It's like you and your siblings can't agree on what to do with the property. Well, you can't be forced to co-own something and it's indivisible, right? Without like dealing with it. So you go to the court and say, hey, we can't agree. Can you just put this thing up for sale? We all get our piece, right? That's what a partition is. And tax sales work the same way, because they had a partial interest that they were granting to the investor. Right. But now with that going away, it's and the reason I brought that up is because the attorney's fees component, there was an ability to recover, and still is today, to recover attorney's fees in a partition action that's tied to a quiet title of a partial interest. But moving forward, there's absolutely an amount that you can recover in the right to the proceeding to foreclose on the right of redemption in Louisiana tax sales in the new system. It says the greater of 25% of the delinquent sum that you're foreclosing on, or $2,500, which doesn't sound like a whole lot of money for legal fees, because you probably file a lawsuit and send the sheriff out and you're at $2,500 almost. But it does say for good cause shown. I can tell you that number is low, but it was a negotiating factor. It was one of these things where different lobbying groups are like saying, fighting with each other. This is where it ended up. And I think what the real caveat there is for other good cause shown. And there will, in our practice, and we do represent tax sale purchasers in Louisiana on the legal side as well, and also connect them with attorneys in other states, that is low, but showing good cause is like where we can really shine in representing other investors in this part of the process, is being able to show anyone that matters, the court or the collector, that it was more than 2,500, so you're going to get that back. Right. So that's a big. So if you start adding it all up, the new system, right, for the investors, you're going to have you're not bidding down ownership anymore. The delinquent sum that's being offered for sale is the flat amount, whatever it is, right? You're bidding down the interest rate, but no less than 0.7. It's still a 3-year redemption. You're going to be required to send redemption period due diligence, but you'll get all your money back by doing it correctly, and by doing it timely, and by proving that you did it. Again, services that Jurisdict helps investors with. And then moving forward, you'll be able to foreclose on your right of redemption as quickly as 3 years and 1 day, and get all of or most of your attorney's fees and legal costs back in the event of a late payment of a termination price, like a post-redemption payment, to stop the foreclosure. And so, really kind of protected in that regard. And of course, because 3-4 years have passed since the first tax sale that the investor got involved, you'll be able to pay subs and get the 5% and the 1% per month on top of the subs that they pay. So it becomes an accumulation of interest that actually increases the overall ROI of the investment in Louisiana.
That's awesome. Well, I know the new laws take effect on sales starting 1/1/26 going forward. Is it as simple as any sale that occurred prior to that is going to use the old system, and new sales are going to use the new system, or is it more complicated at all?
No, it's not more complicated than that. It's going to be segmented based upon the date of the tax sale occurred. And so this the foreclosure component of the new law we won't see that actually play out for years to come, right? Because you have if the first tax sale that it's applicable is 2026, and the soonest you could possibly foreclose on such a tax lien would be 3 years later, we're looking at 2029 when the first lawsuit will be filed under the new law. It will not be retroactive, to put it simply. And so, in fact, now that we're creating like 3 distinct time periods in Louisiana law of where the law was fundamentally different. There aren't a whole lot of lawsuits on the pre-2009 tax sales anymore, but I guess there could be. But it is the law that applies is the law that was in effect at the time of the tax sale, period. Like there might have been changes.
That makes it a little more straightforward. There's some states that weren't that straightforward, and it's created quite the mess. Overall, I guess I'll give my 2 cents. I'd be curious to see your 2 cents. Overall, I mean, this immensely simplifies the process, right? Or I'd say understandability, probably a better way. I don't know if the process probably isn't that much more simple once you understood the old system versus the new system.
Right.
Curiosity, did they actually in updating the statute, did they change the name so it doesn't in all of the language, it used to sound like I'm buying a property. In reality, you're buying a lien on the property. Did they fix all that in this process too?
Yeah, thankfully, because that was the worst part about the old one. And we're still going to throw the word title in there just to make sure that you're totally confused, even though it's totally different. Yeah. Right. No, it's tax lien auction is the event. A tax lien certificate is what you get to memorialize your purchase. And the only thing that was kind of like a little weird was like this termination price thing. But I guess they wanted to draw a distinction between when the payment that's being made is an actual redemption and kind of staying true to that meaning of the word redemption, like within the legal time period to and then something happens after that is really to stop the process, right? Like it's post redemption, but you're stopping its termination price. But yeah, it's no more use of the word title. And so that's
complicated for sure. So for lien folks, right, that were intimidated by the language or didn't quite understand it or didn't like the ownership bid down, right? That was definitely different than, I think I'm only aware of one other state that had implemented something similar. For the lien guys, right, that were scared off by those, items, obviously, it's much more appealing, not only process wise, but return wise is on par, maybe a little different, right? But I think still very much appealing, if not more appealing to lien investors. And for the deed investors that were looking for properties, the process is changing, I think becoming a lot more straightforward that, there will be tax deeds that are sold, right? So if you're not looking to own the property, there's now a process to get what you're owed without owning the property, right? And have to deal with it. And if you're wanting to own the property and not wanting to deal with the lien side, right, there's a process that allows you to participate in those auctions. So in my experience, there's been very few investors that have really been focused on both. They kind of dealt with what it might have been, right, to get whatever they were looking for. And this makes it much more straightforward for both, which is great. Well, it sounds like, quite frankly, Stephen, Louisiana is kind of ahead of the game compared to many states that are changing over as a result of Tyler Hennepin. I know that this didn't necessarily originate in Tyler Hennepin, but I think it made some tweaks at the back end.
Well, it did, yeah. And I know we were running up on our time limit here, but just real quick on the Tyler v. Hennepin, issue, because that was such a prominent issue and I think by this time most tax sale investors, are probably aware of it or can be concerned about how this affects their business. It did affect the ultimate law that was recommended by our committee to be put into place, and what was ultimately approved. There's a very specific process to capture the surplus equity from the foreclosure auction. I'm talking about the new system, right? And to place that in the registry of the court, and to within a certain time period to send out notifications, et cetera. And remember that the Supreme Court in Tyler did not project onto the states, this is how you should go about doing it, they shouldn't. But they simply said not having a system to to provide the opportunity for equity reimbursement to the homeowner in the event of a surplus is bad, right? Anything else is all going to come out of subsequent cases in other states and other circuits as we move forward. And so, arguably there's even a possibility for the partial interest foreclosures under current Louisiana law to be subject to a Tyler suit right? So somebody's going to contest that. Hey, even that 1%, even though it sounds like you're trying to do the right thing by taking the least amount, it's like 1% of what? Right. I mean, you still have to ask that question. Whereas under the new system, it's irrelevant because whatever it is being reserved. Right.
Right.
And then finally, the adjudicated property in Louisiana. I won't get into a big long thing here because we run out of time. But it is its own animal. Adjudicated property is a big long word in Louisiana that this doesn't mean what you think it means. And if you don't know adjudicated property, it means the tax liens that went into the tax lien auction that didn't sell. It's that version in other states, right? And eventually it doesn't get redeemed, and then the parish or the taxing authority has the ability to do something with that to try to get rid of this thing. In the past, up to now, it's been they can, after 3 years, they can hold, put it out for auction, for bid, and have people bid on it. And if that's the case, if someone bids on it, then it has to go through a gauntlet of final due diligence. And that's what the system that I had created for the state of Louisiana back in 2014, that was so successful in getting title insurance, in fact. But that's changing as well. It's becoming a little bit more limited in what and when and where the counties can do that. And I think because they're really trying to put all their eggs in the basket of getting these properties to the traditional tax lien auction and through the ultimate foreclosure outlet through that means. So if there's something that became struck off to the county, if you will, or adjudicated, one thing is for sure, it won't go back into the next year's tax sale anymore. That was always a problem. And then one of the little nuance that's important to investors who are in Louisiana right now is that after buying the property at the certificate at a tax lien auction, under current law, the tax bill, the subsequent tax bills only get sent to the tax sale purchaser and anyone else who may have requested to get notification. The homeowner's not getting it anymore, even though they're still in the redemption period. It's nuts, right? It's just like asking for problems. So now it goes to both, but at least the homeowner continues to get that notification.
Well, let's. It sure sounds like we aren't given the adjudicated process and then how the chains affect that. We're not giving it justice today, because we're running out of time. But I think it's safe to bet Stephen will be able to hop on in the near future and talk about that in more detail. Can I rope you into that?
You got it. Name
All right. Awesome. Well, Steve, I immensely appreciate always your time and helping educate me, helping educate the listeners and how and what's going on in Louisiana. It sounds like things are getting better, and I want to, invite you to connect again and look forward to hearing about the adjudicated process in more detail as well.
Awesome. Yeah, it's a privilege. I love doing this with you. We can talk for hours about this stuff. So cutting down 25 minutes is a good challenge to have. But thanks for having me as always. Look forward to coming back.
Good luck, everybody, on your investment adventures. Hope you learned something today, and we'll talk to you again soon.